The ANC says it has noted the Electoral Court judgment dismissing its application to deregister the MK party. The court found that the ANC had failed to substantiate why it had not objected when the party was registered with the IEC in the first instance. Now, the court went further in citing the ANC's failure to bring an urgent court application when the objection was dismissed by the IEC. In a statement, the governing party says it is not opposed to MK's presence in the ballot paper, provided that the registration was in accordance with the law. The party says it is strongly against the use of the Umkhonto we Sizwe logo and the name. It argues that the Umkhonto we Sizwe history and logo is the heritage of the ANC, which is why they are heading to the High Court in Pietermaritzburg to challenge the patent of the MK. Well, let's take this discussion further. As I alluded to earlier on, we're going to be bringing in legal analyst Mpumelelo Zikalala via video link to weigh in on the ANC's latest developments and really what's transpired in the IEC's case on the deregistration of the MK as a party. That case coming to the fore. Then, Mpumelelo, good afternoon, and thank you for joining us on the SABC at this hour.
Good afternoon to you, and also good afternoon to your viewers.
Mpumelelo, the ANC now having lost its case in the Electoral Court, seeking the deregistration of the newly launched Umkhonto we Sizwe party. Let's get your reaction on this judgment based on the merits of the arguments as well. Unpack that a little bit more for us.
Well, the court was looking at three things. Firstly, the extent of the delay. Secondly, jurisdiction, and then the merits of the matter. With regards to delay, the court was saying, but ANC, if you are really serious about this matter, you would have filed papers much earlier. Most importantly, you would have filed papers in the correct forum before coming to court. That's where the issue of jurisdiction that comes in to say, before you come to court, you start with the IEC, then you go to the commission, and then you go to court. If you are going to miss a step, at least provide us your papers as to why you felt that you needed to miss that particular step and the importance of the step, why it was missed, and whether it would have brought in new facts or different, or provided the relief that you were seeking for. But nonetheless, even if when you look at the merits, the section that you have cited, it is predominantly, which I think was the court was giving us advice in as legal practitioners, was to say the section that you are focusing upon simply seeks to protect the individuals that are doing the registration and not necessarily registered political parties seeking to stop or object to any of the parties being registered. So on those basis, yes, we may have allowed to come into court on an urgent basis, of which we already ruled that the agency isn't there. However, even on the merits, the section that you have cited is incorrect.
Thank you for outlining that and for those opening remarks, because now the MK, of course, will be appearing on the ballot for 2024. You've alluded to the implications and the precedents also that this sets. I wonder if we could just then turn our attention to what's expected tomorrow, because obviously there were two aspects to this case. Talk to us a little bit more about your expectations ahead of what's coming to the fore with the trademark challenge.
Well, tomorrow, the court is going to assess two things. Firstly, is the common law principles when it comes to trademark, the issues of passing off that the ANC is then alleging, and also with the legislation pertaining to copyrights, which then says, whenever I have a name that belongs to me, I have a logo that belongs to me, it can't be utilized without my permission. And even in instances where one seeks to pass off as those that they belong to them, I must be protected by the law. In this instance, then, it has nothing to do with the registration. However, it simply says, despite the fact that you are registered, you can't utilize this particular name or provide a name which is similar to mine. But what they can do, and this is in Umkhonto we Sizwe part, if they are forced or put into a corner, if they use this case, they can come back and say, okay, if you say Umkhonto we Sizwe is a problem, just change the name of the party to Umkhonto we or to Umkhonto we. Those are the names that can be available and be utilized, and also change the logo. But we still keep the green, we still keep the black, and all the other designs which are then applicable as per the logo. So I think tomorrow the fight is mainly about the trading marks, the manner in which a certain brand is identified by members of the public so that they closely associated with it.
And so given the crux of the matter, from your vantage point, how easy or difficult is it going to be for the ANC to prove the MK as their asset formation?
It's going to be extremely difficult. Well, there are ways and means of being able to protect yourself or to being able to claim that particular asset. Firstly, yes, there are common law principles that are there, but you need to be very clear. For example, then the next question would be, who came up with the name of Umkhonto we Sizwe? Is that a person, a member of the ANC? Is there any other document in which it appears that Umkhonto we Sizwe belongs to the ANC? Have it ever claimed as such? Or do we have a military veterans association, which is closely linked to Mkhondo's, which is something that is totally different. The other aspect that was going to come in would be to say, with you being in existence for so many years, why didn't you deem it important to utilize the legislation which is available to you to go and register this particular trademark as belonging to yours? Why wait up until the last moment before you're able to register it and there's a dispute pertaining to it? However, they are still protected by the common law if they can be able to prove ownership. That's the first part, to say this belongs to us, it is owned by us. If it wasn't for the ANC, the name Mkhondo's would not have survived or would not have been there. If they're able to prove on those instances, then all the others, it would be easier to prove that the name belongs to them. But if you can't prove ownership, then you have a very hard battle to fight.
Mpumelelo, just as we wrap up, it's a twofold question. It's just in relation to what transpired earlier at the Electoral Court. Sentiments about, the courts and its biasness, or bias rather, coming through on various fronts in relation to when, individuals or parties lose cases versus when they win. Talk to us a bit about the impact that has on the judiciary and on the function of the courts. And then also just, looking at the Electoral Court having achieved the feat of writing that full judgment, only having about 3 days. I mean, what's the work that went into this? Talk to us about the processes also unfolding on that front, for those who are obviously not privy to what's unfolded.
I think firstly we must applaud the Electoral Court for doing such a sterling job, hearing the matter on an urgent basis and coming up with a judgment as soon as possible. That's what you need, and that's what you need the type of Electoral Court to work in. The only thing or the flaw that may have been is that the leaking of the particular judgment and the insinuation that followed. But I think what I would have expected is that even when, before the court started, the judgment was going to be read, there's some type of comment that would have came in, or maybe from the Office of the Chief Justice, to then say, we are distancing ourselves from any leak that has took place. We are going to fully investigate it. We are compliant with the legal prescripts that are there that say you must be transparent. Hence why we thought we should not deliver this judgment pertaining on paper, just email it to the very relevant members. We thought it was important that we all do it in open court, cameras being there so that you can see that everything is being transparent. But with that put aside, I think we must say congratulations to the Electoral Court. They've done a sterling job in hearing the matter and delivering judgment within the shortest amount of time.